coming to you, when you look at this 306-page judgment and the justices that were seated there, what do you make of it?
It's a very interesting read. I was actually reading through it today. I must confess I've not read the entire 300 pages, but I was able to follow the proceedings live. So I have an idea what each of the justices said. For me, one of the most important positive outcomes of this decision is the emphasis it puts on the right to a fair trial as a non-derogable right. I think it's the first major decision to emphasize the non-derogable nature of that right. And it also goes as far as breaking down the tenets of that right in relation to the bodies that adjudicate criminal cases. It gives very detailed guidance, and it draws not just on our law here, but it also draws on international standards from different bodies, international bodies. It also draws on comparative jurisprudence from different jurisdictions. It also gives a very interesting context, our historical context. I was so excited reading the judgment, especially the judgment of the Chief Justice, and seeing references to the Odoki report, the Constitutional Commission report, because in effect the court is saying we cannot understand where we are if we don't understand where we've come from, and we cannot understand where we are going unless we understand where we are and where we are coming from. And when you look at that historical bit of it, it looks at two areas that are relevant to the case. It looks at the role of the army in a very candid and open manner, you know, attributing some of the governance deficits that we've had, the rule of law deficits that we've had to the conduct of the army, and then drawing on the views of the people, what the people said when we were, you know, working on the Constitution in 1990, from 1990 to 1993, 1990, 95. And it shows how things have evolved. And it's a commitment that, you know, we don't want to go back to that history, relating it to the preamble of the Constitution, which is also very clear that it reflects on our history and it makes a commitment. In other words, the court is saying we need to break from the past, a past that has been characterized by tears, a past that has been characterized by arbitrary action from different agencies of the state. The other thing, and I hope my colleagues here, the lawyers, agree with me, is that the way the judgment is written, it is easy for a non-technical person to follow. I liked the style of writing. Even a non-lawyer, a person that has ordinary comprehension of English should be able to follow. Of course, there are some technical issues here and there, but the person should be able to follow. So I would urge all Ugandans, don't get scared of reading that judgment. It makes very interesting reading. You should be able to comprehend. It has, for those of us that are in legal academia, it has become a tool of education, material to refer to. I used it this afternoon in my criminal procedure class, and it changes the way we've been thinking about so many things. So kudos to the court, well done, Supreme Court. We appreciate. Of course, there are areas here and there that we are still not comfortable with, that we need to look into. For instance, one of the areas we know the court makes a distinction when it applies the principle of retrospectivity to say that a certain category, for a certain category, this decision is prospective. For another category, it has a retrospective effect, and it clearly defines those two categories, direct review and collateral review. There are issues there because if something is unconstitutional, it should be so ab initio. So you cannot say I was tried by a body that is unconstitutional, and then you say, but your decision does not apply to me. Of course, we appreciate the practical challenges that would have arisen from that, but nevertheless, the court should have found ways around that. For instance, it could have used the structural injunction. There are ways that the court should have gone around that, but generally, it's a very good decision, very well written.
Professor, staying with you before I come to Nick, what does this mean for constitutionalism? Because it's not the first time we're seeing what you're talking about, because Article 28(1) talks about guaranteed fair, but also a speedy trial at that. Are these tenants still holding, especially in terms of constitutionalism? Honorable Segona has mentioned the people are still there and nothing is being done.
We've achieved something because previously it's like matters touching on the army were a no-go area. Of course, the Constitutional Court has tried several times, but this time the court comes out strongly in a very detailed opinion, just as I've said. But the other very important difference, and this is very important for constitutionalism, is the involvement of the public, because the public has been involved in pushing for this judgment to be delivered. You cannot have a state based on rule of law, constitutionalism, if the public is indolent. We need a public that is active. We need a civil society that is active. We need civic empowerment, and the events that happened before the judgment was delivered, we saw a degree, it may not be the ideal, but we saw a degree of reawakening of civic empowerment, where people were coming out and saying this judgment has delayed. It is a matter of urgency, considering what we were seeing in court, the way the lawyers were being treated, the way the accused persons were being treated, the conduct of the panel, the conduct of the judge advocate. It reawakened public involvement. So with this push, I think it needs to be sustained. Building a constitutional state is incremental, so you must appreciate every small gain and see how best to make use of it. So we've now achieved this. We now have to target what's the next area that we need to push for reforms and to concretize what we've achieved.
Thank you very much.